45 of 2020. Under the aforesaid facts and circumstances and the discussions made, we are of the view that the conviction is liable to be converted under 304 Part 2 of the IPC, which is accordingly done. Consequently, sentence is altered to rigorous imprisonment for a period of 7 years with a fine of 5,000. In default, with simple imprisonment of 6 months. Appeal accordingly stands partly allowed.
Deeply obliged.
We
Obliged.
record our assistance to the learned amicus.
Obliged.
Our appreciation.
Obliged.
From factional problem, my lord, this matter,
10 is of old matter.
my lord,
10 is of 2016.
my lord.
Why are you mentioning 2016 matter? In 2026, we are not adjourning. Sorry.
I'd like to mention item number 25.
Yes.
I have received a instruction. I may be allowed to 1 week time to file affidavit on behalf of GST. Also. Instruction is listed.
Okay. On a request made by Dr. Gogoi, the learned standing counsel CGST,
Lords,
2 weeks, 1 week time.
1 week.
A week's time is granted to enable him to file affidavit in opposition.
Lords.
We give a date.
Lordship, I'm for the petition.
What's the date, maybe?
We'll fix a date, madam.
Yes, sir.
What is your name?
S. Sarkar.
Ms. S. Circle Learned Counsel for the petitioners is present. List on today is 18th. Today is 19th. We'll have it on 27th of February, okay?
Lords.
Sir,
When-
there's an interim order.
Interim order passed earlier stands extended till the next date of listing.
I'm deeply obliged.
My lord, I beg to mention for withdrawal, my lord, for tomorrow, my lord,
Pertaining to this bench,
lordship, that's time, obliged.
Yeah, item 22, my language for a traditional lordship, I need 2 weeks time to file it.
22 of a matter of which year?
22.
22. What are you doing, Mr. Goswami? 22 matter in 26. After 4 years, you are seeking time to file affidavit. What is this? 4 years have gone.
I have received the instructions, lordship.
Okay. Last chance. 3 N. Goswami, Learned State Council prays for time to file affidavit in opposition. Full stop. Also heard Sri Anjit Khatani, Learned Counsel for the petitioner. Para. Considering that this writ petition is pending since the year 2022, our last chance is granted to file affidavit in opposition. Full stop. List on 11th of March.
May it please your lordship. Lordship, this matter was last listed in 2017. It pertains to tender.
17 matter.
Yes, your lordship.
Matter of
Matter last was listed in 2017. It's a 2016 matter, your lordship. Your lordship, we have to get instruction from our client if the cause of action still survives, your lordship.
We'll have it tomorrow. Bring it.
Lordship.
There may not be any cause of action. We'll close this. Tender was for what?
Your lordship, it was a response of we filed the writ petition whereby the lowest bid submitted.
No, tender was the work was for what? What
uh,
was the work purpose of the tender?
It was a military engineering services, your lordship. It was an e-tender. It was for maintenance to street security light and allied works at camp
This
paving.
is for a tenure. It is gone. You bring it tomorrow. We'll
Yes,
close
your
it. Yes, Mr. Chakraborty.
Obliged.
In regard to item number 18,
Yes.
the notification impugned, the writ petition has been withdrawn by the department. So in view of the matter, my lord, this writ petition has become fruitless.
Okay.
May I place this?
Yes.
Item
Heard
number
Sri D. Chakraborty, Learned Counsel for the petitioner. Also heard. Yes. Sri N. Goswami, Learned State Council. Mr. Day, is he there? Day or A. Barua?
has informed that he has difficulty today in coming, so he has conveyed that.
Also heard KK Day, is he there in the court? नाम बाद में लिखिए हाँ full stop. Sri Chakraborty, the Learned Counsel, has informed that vide a subsequent notification dated 15/7/2025 the impugned order has been withdrawn. Full stop. He submits that in view of such development, there would be no requirement to press this petition. Full stop. Para. Writ petition accordingly stands dismissed on withdrawal.
Interim may be vacated.
The interim order passed earlier stands vacated. Para. Copy of the notification dated 15/7/2025 is made part of the records.
May it please your lordship. I'd like to mention,
Very good. I'll see to deliver, no? Vamos. Yes,
lordship, I beg to mention 4 writ petitions pertaining to remission. Lordship, there's some urgency in the matter because the next board is scheduled to sit in the coming month. So lordship, for the orders column I'm mentioning, lordship will have it on any day.
remission matter.
Yes,
Okay.
sir. There are 4 similar
1 weeks. Okay, when do you want?
any date convenient.
Next Wednesday.
Okay.
Lordship, I beg to mention item number 20.
20. Yes.
Also, Mr. SGP is having some personal difficulty, Lordship. Lordship, can you take up this matter?
Here for the respondent.
Yes, Lordship.
When do you want?
After 2 weeks, Lordship.
Okay, on a request made on behalf of 3 HCTR.
Yes, Lordship, and item 32 is.
Just a minute. Similar.
Yes, Lordship, it's connected.
Same order. Okay? On a request made on behalf of 3 HCTR, London Standing Council. CGST. Income tax. Matter is adjourned by 2 weeks. Full stop. We give a date, madam. List on 9th of March.
Both the item there in interim order.
Interim order passed earlier. Interim order, if any, stands extended. Directly. In which interim order is there? Both. The interim order passed earlier stands extended till the next date. 19 and 20 and
20 and 32.
what key date could I miss? 9, 3 and 20 and 32. Okay, interim order. Okay, madam.
Lordship, I beg to mention for listing a writ petition pertaining to the year 2020, Lordship.
2020.
Yes, Lordship.
What is the subject matter?
Lordship, the claim in the writ petition is for compensation from the respondent. So,
20 matter. Okay, we'll have it next Monday.
Lordship, I do pleasure.
May I please, your lordship?
Lordship. Yes, sir.
With your consent, I beg to mention item number 60. Senior counsel, Mr. Encidas is having some personal difficulty today.
Okay. On a request made on behalf of 3 NCDAS, London Senior Counsel for the respond numbers 2, 3 and 4. Matter is adjourned to be listed after a week.
After 2 weeks, lordship.
After 2 weeks.
No, that kind of fix, my lord.
Okay. On request, list on
10th of March.
10th of March. 10/3.
May please, your lordship, I beg to mention for listing a matter which was last posted on 17/10/25, lordship.
Matter of which year?
25.
25. What is the urgency?
Actually, lordship is a compensation matter. So.
Sorry. Yes.
Okay, I beg to item number 24, lordship.
24. Yes.
There's some personal difficulty, that may be acted for that.
Who has got personal difficulty?
Please inhabit.
Okay. Inform the other side.
I will inform you.
No, I will not do. I will not do. You have to inform first. Don't make a mention of informing. Inform and come. We'll adjourn it. Yes.
May it please, your lordship, with the consent of other side, I beg to mention item number 30.
30.
30, lordship.
Yes.
Lordship,
Hearing matter.
hearing matter, lordship, as per the last order, with the 29/1, the trial court record has been called for, but which was not received yet.
There is an office note. We'll have to
Office.
see the office note. Okay. Yeah. Have you checked the office note?
Yes, take the office name.
Why is TCR required?
Lordship.
Lordship has, there is a cross-examination, there is a dispute between the whether he is a protected employee or not. The cement factory
It
has
pertains to an award of
award of industrial tribunal.
office note কি কৈছে? Hmm? Hmm. Learned. Is case of 10 of 1992 or 91?
This is a case of 1991, Lordship.
Hmm? There's a office note says that it should be 10 of 1992.
Lordship, here it is the 1991 Lordship, the annex, which was award was annexed. as-
No, they have said that in the certified copy, due to inadvertence, it was written as case of 10 of 1991. It should have been 10 of 1992. Please, both of you have a look at the office note.
Lordship.
You come back, we'll pass appropriate orders.
I will inform.
Huh?
I will inform. Item number 24.
Have you informed?
Yes.
Whom have you informed?
I will be.
Huh? RDB. Item number
24. Lordship.
24. On a request made on behalf of the petitioner, matter is adjourned by 2 weeks. List on 9th of March, 9/3. Okay?
May I please, your lordship, I beg to mention item number 21, lordship.
Yes.
Concern of the other side, lordship. In this case, lordship, petitioner number 1 has already died. I am be allowed to 3 weeks time to file substitution petition, lordship.
Petition number 1 has
One
died.
died, lordship.
Okay. Yes, madam, yeah, who's? Okay. Now, what is your name?
P. Gohai, lordship.
Sri P. Gohai, Learned Counsel for the petitioner has informed, petitioners, has informed that the petition number 1 has passed away in the meantime. Full stop. He accordingly prays for time to file appropriate application for substitution. Also heard GMDA, who's for GMDA normally? As also heard, Sri S.S. Royce, Learned State Council, Sri S. Bora, Learned Standing Council, GMDA, and Sri D.M. Nath, Learned Council for the S1 of 5 and 6. Para? In view of the above, matter stands adjourned by 2 weeks to enable filing of appropriate application.
Please.
Yes.
May I please, your lordship, I beg to mention for listing of the writ petition, lordship. There are 3 writ petition for motion, lordship.
Motion, yes, you can do it. When do you want? Monday?
Lordship, tomorrow.
If it's fine, tomorrow also you can have, no problem.
May I please, your lordship. Lordship, I beg to mention item number 14, lordship.
1-4.
1-4.
Yes.
My lord, may kindly allow me to withdraw this writ petition.
Sri M. Ahmed, Learned Counsel for the petitioner, submits that he has instructions not to press this writ petition. First of also heard Sri. Who? Oh. Also, is he there in the court? If he's not there, we cannot record. Also heard Sri S.S. Sri N. Goswami, Learned State Council. Para? Writ petition is accordingly dismissed as not pressed.
Highly obliged.
May I please, your lordship?
Yes.
For listing new motion.
Motion?
Motion tomorrow.
Tomorrow. Urgency is there or what?
Urgency is there.
What urgency?
As
Monday you will not be there. That is the urgency.
unmarried data freedom fighter account is being withheld. Without serving notice that also.
What is the urgency? This for tomorrow.
This account is being withheld, this one, she is not operating without information.
When was it withheld? When was it withheld?
She is a data.
When was it withheld?
4 days back.
Then what is the urgency? We can have it on Monday.
Urgency is there, I want to, we were not.
That is not, that is an important matter. That's not an urgent, that's not an extremely urgent matter that tomorrow something is going to happen.
Because.
If you have a problem on Monday, tell us.
Then the question of
Monday
like-
you are going to,
question of
going to
livelihood,
your
operating
native place.
bank account not been allowed to.
So what is
operate.
going to happen in one day?
My lord,
Within one day, what is going to happen?
nothing.
Then-
But time paid before lordship for tomorrow. Yes. If the lordship pleases, then only others have to go for whatever lordship passes order, I will go by that.
Okay, if you are insisting, okay, tomorrow.
I don't-
Yes,
Lordship,
checked it.
Lordship, in page number 69, it is written as 10 of 1991. In say, page number 90, it is written as 10 of 1992.
But they have given a clarification. It should be 1992.
Lordship.
And therefore a judicial order is required. That's how to file to.
Lordship,
The awarding that page
yeah, was
69.
page 69 awarded.
This
Uh,
is 1991. In page number 90.
90 and
The order was passed.
order was passed.
Yes,
It is written
please,
as
please give your names. What is your name?
SRA Nasir.
Hertz 3 SI Nasir. You're on record, Mr. Nasir?
Yes, Lordship.
Item number Kimanito?
30, Lordship.
13
30.
30
Lordship.
SR Nasir. And what is your name?
Remission.
BB?
DP Sharma.
BP Sharma. On behalf of whom?
Sir, what's it? It's a J. Roy.
J. Roy. And all as well as SS Roy pehle likhiye, G. And BP Sharma for response number?
That's what 2 and 3.
2 and 3. Full stop. Para. Wide order dated 29/1/2026. This court had called for the records connected with the award. Full stop. Accordingly, comma, the records were requisitioned by this office. Full stop. However, there is a communication issued by the Registrar, Industrial Tribunal, Gauhati, that though in the certified copy of the award, the case number is written as 10 of 1991, comma, the same should have been case number 10 of 1992, full stop. Accordingly, an office note has been prepared dated 12/2/2026, whereby the aforesaid aspect is prayed to be clarified. Full stop. Para. This court, in the order dated 29/1/2026, had called for the records of the impugned award. Full stop. There was no specific mention of the case number. Full stop. Be that as it may, comma, if the correct case number is 10 of 1992, comma, it is the records of that case which is required to be transmitted. Full stop. The same may accordingly be done, and the matter be listed for hearing immediately on receipt of the same.
Deeply applied.
I didn't want to eat.
Yes, what are these matters, madam?
May I please? My lord, these are for compensation, my lord.
Compensation for?
For my lord, Ereka nuts were seized, my lord.
Yeah.
Ereka nuts were seized.
Not
and
the other matters of
my
21.
lord, that is what I'm saying. My lord, of rest of the matters, that is item number 2 to 8, notice was issued. It is fixed for hearing. Dada, to the ribbon. Only the item number 1 is new matter, my lord.
Item number 1 is a fresh matter.
Fresh matter, my lord. So my lord, notice may be issued and fixed for hearing with.
But it's pending since 2020 when?
My lord, 21 some matters and 22 and 23 some matters.
So we can issue notice here.
Not here is that item number 2 to 8 are maybe similar, but one.
One is not similar.
Yes, Lord. Here, Lordship, execution order has been passed, the preferred appeal is pending. In other cases, Lordship, notice under section 124 has been issued.
No, here we can issue notice at this stage.
Lordship may please to see. If Lordship is fine, I have no objection. If not, but-
You are objecting on the issuance of notice also.
No, Lordship, yes, because Lordship, here alternative remedy is there. They preferred appeal before the CSAT. That is, as per writ petition, that is still pending. And final order was passed. Lordship may come to page.
The appeal has been disposed of.
No, Lordship, that my learned friend we can appraise, Lordship. Whether appeal has been disposed of.
But that appeal, as per your information, it is
Yes.
pending.
Yes, Lordship.
Madam, you take instructions.
No, my lord. Please, please.
You took instructions, madam. You have perhaps you
Well-
have not been properly briefed.
Page 216. This is the memo of appeal. And Lordship, final order has been passed. In other cases, Lordship, after issuing notice, they didn't appear, so the goods were destroyed as per the manual of the department. So there is a basic difference between item number 2 to 8 and 1.
My lord, this is the, my landlord, what my landlord senior is saying, these are different things, my lord. What this 226 is about is compensation, my lord. This is different. We are not challenging the order of Chested or order of GST or anything, my lord. This is basically we are saying, my lord, all the matters are similar. My lord may see the order I have just
But for
submitted, my lord.
compensation, how do you come to a writ court?
My lord,
How do you assess a
my lord,
compensation?
that I'll satisfy. My lord may issue notice and fix.
No,
other
notice,
matters,
no,
my lord.
issuance of notice is not routine, madam.
My lord,
To get a notice issued, you have to make out a case.
my lord, my lord,
How does the writ court assess compensation?
my lord. My lord,
What
because,
yardstick do you have? How do you adduce evidence in a writ court?
my lord,
You go to the civil court, pray for damages, will give you liberty to go to the civil
my
court.
lord,
You may have a good case. We are not saying anything on
my
merits,
lord,
but how do you prove it?
my lord, that is what I'm
These are
saying.
all factual matters which are factual in nature. And once you raise the issue, they'll dispute it.
My lord,
And then in any case, you'll be spending time here.
my lord. My lord, because other from 21 and 22 other similar matters are pending, my lord. So my lord may kindly issue notice and fix it for hearing after Bihu vacation. I'll satisfy and do the hearing, my lord.
Mr. Kyle, so far as this matter is concerned,
Because,
Madam is trying to make out a case that she is not aggrieved.
No, Lordship, I'm not objecting to her prayer. Lordship, may please to see. There is a basic difference between item number 210 and 1.
no, my
Lordship, may come to page 321. This is the order in original. Here, Lordship, page 321.
321.
321. Paragraph 30.
Yes.
Paragraph 30, I order absolute confiscation of 24,500 kg
Hmm.
processed dried areca nut
Hmm.
amounting to be so and so. I order confiscation. Lordship, thereafter page 216. 216.
216.
Lordship. The writ petition of preferred appeal before the CSET.
Yes.
The outcome of it, they have not annexed any order, whether the appeal is admitted or whether it has been pending or dismissed.
Oh.
And when there is a lawful order of confiscation of goods, how they can claim compensation also here? They have to satisfy this and work out whether appeal has been pending or it is disposed of or whatever it may be.
Yes, he is correct. Unless, see, the compensation part precedes,
My lord.
is a consequence after declaring the confiscation process as illegal.
my lord,
First hurdle is
my
to
lord,
overcome the aspect of confiscation and make out a case of illegality.
my lord,
Now that illegality is the subject matter of challenge in the appeal.
my lord.
You have to inform us what has happened to the
My lord.
appeal.
My lord, the issue here is, my lord, the item number 2 and 8 are, my lord, saying these are different. These are not different. From the same scissor.
No,
list,
let
same
us,
scissor.
we are not adjudicating
My
2 and 8. We are only on item number
My-
1.
My lord,
One has two prayers, two components.
my lord,
First, to declare the confiscation as illegal,
my lord,
and secondly, to for a prayer for compensation.
my lord,
You have to overcome, you have to succeed in the first prayer.
My lord.
Second is consequential.
my lord,
Then also the question might come whether you would be entitled to pay compensation in a writ court.
my lord,
We may declare it
So-
illegal and you still send it to the civil court.
my lord,
With this order, you can pay compensation.
my lord,
But first, so far as the legality of this order is concerned, that is the subject matter of challenge in an appeal,
my lord.
the outcome of which has not been disclosed to us.
My lord, the order of Chested or order of Shillong, we are not challenging them.
We understand.
My lord,
Then if that first part, there is no adjudication, how do you claim compensation?
no, my lord. I'm saying, all I'm saying is, I have annexed all the documents here, my lord. We are saying is, our goods were seized. Thereafter, seized by Assam police, my lord. Thereafter, we have challenged the FIR, my lord, my lord.
Madam, you come to your prayer.
My lord,
You come to your prayer. We cannot grant you this. Mr. Kyle has a point. Otherwise, issuing notice was not a big problem.
my
Come to the prayer at page 32.
Please.
Issue a writ in the nature manner should not be setting aside the illegal seizure and consignment of areca. This is the subject matter before
Yes.
the Just
Yes.
that,
Yes, my lord. No, my lord. That is the matter. I'm
Yes.
not saying that is not the
and
matter.
thereafter,
but-
by declaring the process of destruction to be illegal and to make good the loss the petitioner suffered.
My lord. My lord, because,
At least bring us what
My-
is the outcome
yes, that I'll bring.
that will
But
bring.
what I'm trying to say is, my lord, the goods were seized by Assam police. Then we filed 226, under 226 application was filed before this honorable court. And this honorable court, that was again challenged in a writ appeal. That order I have annexed with this petition, my lord. Our honorable high court take a view that because the custom and DRI is involved, Assam police cannot seize the goods because the custom, GST and other goods are involved. Thereafter, Assam police handed over the goods to the custom and DRI, my lord. Thereafter, without any adjudication, my lord, that is where aggrieved, my lord. Without any adjudication, my lord, goods were destroyed. We have given multiple representations. 25 trucks of goods were seized, my lord. All of them,
You get the information, what has happened to your appeal?
my lord. I'll take instruction that
Heard.
on that, my lord.
Ms. Jia, the learned counsel for the petitioner. Full stop. The writ petition has been filed challenging a seizure of consignment of areca nuts by DRI case number so and so, page 32, date three. And the show cause notice so and so. The subsequent prayer is for grant of compensation. Full stop. Para. 3. Kyle, the learned senior standing counsel, CGST, Customs, has however raised a preliminary objection by objection on the maintainability of this writ petition. Full stop. He has submitted that admittedly the petitioner has preferred an appeal before the appellate tribunal, and the memo of appeal has also been enclosed in the writ petition. Full stop. He has submitted that the outcome of the appeal has not been disclosed. Full stop. He has also raised an objection that irrespective of the outcome of the appeal, a writ court would not be the proper forum for assessing compensation, which would need a factual determination. Para. Ms. M. Das, learned counsel, appearing on behalf of 3SK Medi, CGC is also present. Para. Before proceeding further, this court is of the opinion that the petitioner is required to at least disclose the outcome of the appeal, which has been enclosed in the writ petition as annexure
Page 216.
at page 216. Para. How much time? 2 weeks?
After vacation, my lord.
Which vacation?
Bihu vacation, my lord. My lord, because
Bihu vacation? When is Bihu vacation? Which Bihu?
April, my lord.
Next month, next January.
My lord.
Next January. Bhogali Bihu.
I'll have to.
2 weeks, 2 weeks. You're on vacation mode, madam, in February. Very good. After 2 weeks, list on today is 19th. We'll have it on 11th of March.
My lord. Along with the other matters, my lord.
Others, we are not passing any orders.
My lord, then
Others are not before us. It is only this matter is before us.
obliged.
Item 1. In the rest, you can write as per earlier orders. These matters can be listed along with swings.
Obliged.
What is this ST store, madam? You had given.
Yes.
Yeah, 2 to 8 lots.
Huh?
The status of other matters.
Why did you give
My
this?
lord, because it is fixed for hearing. That was what I was saying.
Right, please, your lordship.
Yes, 15 matter.
Please, was a 15 meter lordship, the last order. There is action to both lordship, both by plain and to get certain instructions.
Communicated with the department or the meeting company,
Hmm?
irrigation department, because the process was fresh, started on 25th June.
No, 15 meter, I'm not going to adjourn. We're going to dispose of. What is it, Mr.?
The land of the petitioners were acquired way back in 1983, Your Lordship. 5.5 bigha of the land. And 3
5.5 bigha
of
land acquired.
land of the petitioners were acquired, Your Lordship.
When?
In the year 1983.
83, okay.
Now, 3 LA cases were initiated because there were 3 separate ducts. So 3 LA cases were initiated. LA case number 14, 13, 14, and 15 by the under the then Land Acquisition Act, Your Lordship.
Hmm.
Ultimately, they made out a preliminary estimate and forwarded it to the chief engineer. Thereafter, Your Lordship, they were supposed to publish notification. That notification was not published within 1 year. As a result, Your Lordship, the initial estimate that they have made, it had gone. Thereafter, a fresh estimate was prepared then, Your Lordship. And then after preparation of fresh estimate, Your Lordship, a notification was issued. But notification was also not issued, and subsequently no payment of compensation has been made till date, Your Lordship. Now, they acquired this land for purpose of construction of irrigation office, Your Lordship. About 50% of the land they have used for the construction, but the remaining 50% of the land has remained unused. And therefore, Your Lordship, we have come with a prayer to give the due compensation for the land that they have already taken possession of and to return back the remaining 50% of the land, Your Lordship. In the meantime, they have submitted that they have initiated fresh proposal for determination of the compensation afresh.
When was it done?
It was lordship started in 2025, lordship.
When?
2nd February, lordship.
You are not denying the aspect of the acquisition of land?
No. Just 2 things, lordship, only 2 things, lordship.
Just a minute. First process has been, for assessment has been
Started.
initiated in 2025.
Lordship.
Okay.
For the land that they have already acquired, that is under their occupation. And for the
And what
remaining-
about the unused land?
Lordship, they have not taken decision, lordship. This is the what I want to submit to this court, lordship. What they are doing, lordship.
No, if you have acquired the land and you're not utilizing, you have to pay the entire value. But if you take a decision that this part, since it is unused, we return it back, the compensation would automatically be
Lordship,
reduced.
I will have the instruction after lordship fix the case after 3 weeks, lordship, that may be fixed.
No, we are not fair. We will ask you to finalize and take a decision
Lordship, then that will be.
within a specified time.
Lordship.
It's already delayed.
Lordship, that will.
Mr. Roy,
Lordship.
no point. We
Lordship,
cannot
lordship,
adjourn a
absolutely,
matter of
absolutely.
2015. Okay,
Absolutely.
that is the case.
Lordship.
Lordship.
Section 99 says that they cannot change the purpose. If for the building purpose they require, they can retain it. But in the meantime, that
No,
might-
since
It is admitted.
it is admitted that in 2025 a fresh process of assessment is on,
Yes,
we'll direct for completion of the process
Yes.
within a specified time.
yes.
Give the compensation amount. You are aggrieved. If you are aggrieved, you can approach the court, because if presently the assessment is done, it would be the 2013 Act.
Yes.
So under 64, you have the right to even pray for a
Yes.
reference.
Yes.
Okay.
And so far as unused land is there, Your Lordship. they
That
may-
will take up.
We'll take the decision, lordship, may direct.
Okay. The approach to this court under Article 226 of the Constitution of India has been made with the following prayer. Page 7, prayer 4. Para. As per the facts projected, comma, the petitioners are the owners of certain agricultural land measuring 5.5 bighas in village Sahabad in the district of Hailakandi. Please have your seat, Mr.
Lordship.
The aforesaid land was the subject matter of acquisition in a process initiated in the year 1983. Full stop. However, due to some technicalities, the initial estimate was lapsed and thereafter fresh estimate was made. Full stop. The purpose for the acquisition was for construction of an office of the irrigation department. Full stop. It is the case of the petitioners that while the land was acquired, comma, only 50% of the land has been utilized for the purpose of construction of the office and 50% is remaining unused. The compensation amount has also not been finally assessed and paid. Full stop. Para. Sri Laskar, the learned council. No, I have heard Sri so-and-so, huh? SSY, Nananu Padha, Tending Council Irrigation. Huh? Sri Laskar, the learned council for the petitioners, has submitted that the that the petitioners are legally entitled for the due compensation in accordance with law, and the land being acquired in the year 1983, non-payment, non-release of the same has caused immense hardships. Full stop. Para. Hardships. Full stop. He has also submitted that since 50% of the land which was the subject matter.
Increase of 50%. Some portion of land has.
No, that is his submission. He has also contended that since only 50% of the land which was the subject matter of acquisition has been utilized, the rest 50% should be returned to the petitioners.
After section 101 of the new act, your lordship, there is a provision.
He has also referred, and in this connection, he has referred to the provisions of section 101 of the
Act of
Land Acquisition Act 2013. Put on right to fair compensation. Within bracket Act of 2013. Para. Three. Both Sri S.S. Roy, Learned State Council, and Sri N. Upadhyay, Learned Standing Council Irrigation, has submitted that there is no dispute to the aspect of acquisition of land, which was for a public purpose, namely for the construction of an irrigation office, for the irrigation department. Full stop. He has also, it is also submitted that due to some technical lapse, the initial estimate could not be brought to a logical conclusion. Full stop. However, in the year 2025, a fresh process for assessment has been taken up, which is taken up. Full stop. Para. Sri Laskar, the Learned Council for the petitioners, has submitted that his clients are also aware of the fresh process which has been initiated in the year 2025. Full stop. Para. Since there is no dispute in the bar that a fresh process has been initiated for assessment of the compensation, the writ petition is disposed of by directing the completion of the process expeditiously, and in any case within a period of 3 months, 90 days from the date of receipt of a certified copy of this order. Full stop. And apart from assessing the compensation, a speaking order is also required to be passed on the aspect of the portion of land which, according to the petitioner, has remained unutilized. Full stop. It is needless to add that the petitioners, if aggrieved by the adequacy or otherwise of the compensation, would have the right to approach the appropriate forum under the law. Writ petition stands disposed of.
Highly
Obliged.
May it please your lordship. My lord, I pray for compensation. My lord, the Assam State Acquisition Zavindari Act 1951. And my lord, this petitioner two compensation case number, my lord, against the petitioner approach this honorable court.
Please tell us the facts, Mr. Hussain.
My lord, this Government of Assam acquisition the land.
Your land has been acquired.
Acquired, my lord.
Acquired.
Acquired. And
How
my
many
lord,
of you are there?
two numbers of compensation case, page number 6, my lord.
Land
Total
of-
land,
la-
1098 biga,
Land of petitioner acquired.
acquired, my lord.
And two compensation case was there.
Yeah, my lord.
Page
Page 6, my lord.
6.
Page 6. I given the chart, my lord. Page number 6.
Yes.
The serial number 88, my lord. Compensation case number and compensation case number 1 and 2, my lord. 3-1M67, 3-2M67.
Yes.
My lord, this number 1, 994 biga, 2 kata 18 lesa, and second, my lord, 103 biga, 3 kata 18 lesa. Total, my lord, 1098 biga, 1 kata 16 lesa. Thereafter, my lord, the petitioner, the land was acquired. Thereafter, my lord, the petitioner submitted a various representation and documents, and the page number, my lord, the 7. Kindly see page number 7, my lord. The order dated, page number 7
Yes.
is top, my lord. A statement, the order dated 3/4/1967 of the Deputy Secretary to the Government of Assam, Revenue Department is as the mention as follows. The number, my lord, RRZ 212-6639 in exercise of power conferred by such section 1 of section 3 of the Assam State Acquisition Zavindari Act 1951. Amended, the government of Assam is pleased to declare that the tenure of the district of the Golpara as specified below shall stand transferred to vest in the state free from all encumbrance with the effect from first day of Bohag 15.
Now, how do you arrive at this figure of 37 lakhs?
Thereafter, my lord, description of the tenure, my lord, land description, my lord.
No,
Under
how
the
do you,
manifesto-
Mr. Hussain, how do you arrive at this figure of 37 lakhs 50,000? In your prayer at page 23, you have prayed for a direction to release 37 lakhs 50,000. How is this figure? Have you arrived at this figure?
Figure, my lord, as per my lord, this, my lord, this was issued by the, my lord, Deputy Secretary to the Government of Assam, page 8, my lord. This is the statement, I not the copy, my lord. Page 8, the Deputy Secretary to Government of Assam, Revenue Department, my lord. This is the statement of the, my lord, government. Thereafter, my lord, the DC submitted, my lord, this affidavit in opposition, and that opposition, my lord, he is not denied, my lord. And there, my lord,
Mr. Hussain, where do you arrive at this figure? They have given a figure that you are entitled to this amount.
when, my lord, the land was acquisition, my lord, the my lord, the authority, my lord, issued to submit the form number B against this land, my lord. Thereafter, I submitted the form, page 37. Page 37. I submitted the form, my lord, against the land, my lord. This is the original owner of the.
Mr. Hussain, you are not answering the question. From where have you arrived at this figure of 37 lakhs 50,000? Which document? From which document are you claiming 37 lakhs 50,000?
I am statement, my lord, already mentioned, my lord, all the.
Mr. Roy, We're not getting any assistance.
My lord, kindly see the affidavit in opposition, my lord.
10-4, we have seen 10-4. Last order.
My lord, your lordship, kindly see the DC affidavit in opposition.
He was asked to file an affidavit.
You're right. Affidavit filed or not?
Not filed.
Not filed. After 10-4, you have not filed the affidavit.
My lord, I filed the affidavit in opposition, my lord.
No, not opposition. On 10-4-2023, our important question on the maintainability of writ petition has been raised. For an acquisition of 67, you have approached the court in 2016 without disclosing the particulars. And this order was passed 3 years back.
10-4-23.
Which your petition cannot be, you cannot continue with this petition. We're closing it.
My lord, my humble submission, my lord, I filed the representation to the concerned authority, my lord. That consideration may be for direction the inquiry and verify the.
How do you explain the delay of 1967 to 2016?
I filed the representation before the concerned authority, my lord.
We're dismissing this.
My
Heard.
lord, my humble submission before your lordship, my lord.
We have heard your submission on 10-4-2023, 3 years back. You were directed to file an affidavit to explain your position. You have not done. There is no bona fide on your part. Heard Sri J. Hussain, learned counsel.
Representation may be considered for
Z.
direction.
Hussain, learned counsel for the
my lord.
petitioners. Also heard Sri S. Roy,
And my lord, the
learned.
the deputy commissioner filed the affidavit opposition. My lord, kindly see the deputy commissioner.
How do you explain 10-4-2023, Mr. Hussain, before making any submission? Where is your affidavit? After 10-4. Heard Sri J. Hussain, learned counsel for
My
the
lord,
petitioners. Also heard
The-
Sri S. Roy,
Then adjourn the, my lord, I. for
SS Roy,
further, my
learned
lord.
State Council. Para. The instant application under Article 226 of the Constitution of India has been filed with the following prayer. Full stop. A bare perusal of the prayer and the other averments would show that compensation for acquisition of land, which was admittedly made in the year 1967, has been sought to be claimed by means of this writ petition filed in the year 2016. Full stop para. This court, while considering this matter on 10-4-2023, has passed the following order. 10-4 court. Though 3 weeks was granted to the petitioner to file an additional affidavit, almost 3 years have passed and no such affidavit has been filed. Para. Today, when the matter has been called upon, the learned counsel, Mr. Hussain, Sri Hussain, had made a prayer for adjournment, which however has been rejected as taking into view that almost 3 years have passed since the last order and no such affidavit has been filed. Para. It is a settled position of law that this court, exercising powers under Article 226 of the Constitution of India, is a court of equity, wherein the conduct of the party approaching this court is of paramount importance. Full stop. It is a settled position of law that though the Limitation Act per se to 1963 per se may not be strictly applicable in a writ proceeding, the aspect of laches would definitely be there. Full stop. In this connection, it would be beneficial to refer to the observations made by a constitution bench of the Honorable Supreme Court in the case of Bhailal Bhai versus State of Madhya Pradesh, wherein the following observations were made. Para. There is no explanation of any nature regarding the inordinate delay of more of about 50 years. Full stop. The explanation that representations have been filed would not, by any stretch of imagination, extend the cause of action. Para. On the aforesaid consideration, this court is of the opinion that this writ petition is not liable to be continued
lord.
any further, and the same is accordingly dismissed. Yes,
My lord, this,
yes, next.
my lord, this petitioner is, my lord, this Thapar, my lord, if on or.
From 67, you come to the court in 2016.
So, my lord, that is why, my lord, I apology for, my lord, of time, my lord, for filing.
It has
this,
been
my
rejected.
lord. Otherwise, my lord.
Yes,
this-
next. We have passed the order. Yes, next.
Otherwise, my lord, the petitioner. On observation may be given, my lord.
Next. Yes, Mr. Borough.
There's an office note dated 4/2/2026, which came to our notice today, my lord. I'll file that amended cause list within 2 days, my lord. By tomorrow, I'll file it, my lord.
You have not taken steps for 5 also.
No, step 5 has already, my lord, expired. And that is why, my lord, the name was struck off. And but then office note reveals that we have to file an amended cause.
When was the order passed?
That office note is, my lord.
No, not the office, the order of this court.
That order, my lord, will find 27/1/2020.
Produced the office note dated 4/2/2026, which reveals that the learned counsel for the petitioner has not submitted any amended cause title after the expiry of the responsible 5 para. 3 A.K. Barua, learned counsel for the petitioner, submits that such amended cause title would be filed within a period of 2 days from today. Para. List on, we give a date, old matters, we cannot list on today's 19th, list on 26th of February, along with the amended cost title.
6th of 26th.
26th. Next Thursday.
All right.
But ensure that you file it.
I'll file it within 2 days. All right.
13. This is a tender order of 2016. I don't think that much anything is happened in this. Tender was rejected. This case was. And the case was not listed so many times now. Right? The loan gets listed on it.
But there's an interim order. What was the tender for? NIT for?
Maintenance of street security license and
We'll ask you to go for a fresh NIT.
I think Probin Monto was there. I have to talk to him. He is not there. Another team. I don't know. I'll collect the phone number. I'll
Try to have him here because there's no point of restraining you
yes.
from going ahead with the NIT. If his tender was rejected and had gone for a fresh bid, which was the subject matter of challenge, there was a stay order. Now, after so many years, there will be change of rates also. Under those changed circumstances, will allow you to hold a fresh NIT by giving the petitioner a fair opportunity to contest. Okay.
I'll take the phone number. Phone number is not there. I'll take the from the file.
You come back after some time. If he's there, we'll pass this order. If he's not there, we'll dismiss it for default. Yes.
My lord, this matter may be withdrawn, my lord.
Oh?
Or withdraw, my lord, for legal.
Well, past order is not like this.
Otherwise, suffering the petition.
There's no suffering. Don't make a submission of this nature. If you can wait from 67 to 16, there's no cause of action actually. These are all afterthoughts. You should advise your client not to come to the writ court after 50 years. Yes.
My lord,
15.
here respondent has directed to file an affidavit, my lord, as per the order dated, my lord, 13/11/2024, my lord. My lord, matter regarding, my lord, my DAG has been wrongly inserted in, during the land acquisition for the defense, my lord. It was inserted as in the government land, my lord, wrongly. At page 24 is the survey report, my lord. In the survey report, it is
Yes,
reflected.
Mr. Goswami, what is your instruction?
Lordship, we have done the joint survey, Lordship. It is found that this is plot of land outside that.
Then,
Then, my lord, we are, because of it is inserted in the, my lord, government land, we are not able to give the land revenues, my lord. In the records, it is recorded as a government land, my lord. So if,
you are making a submission on the basis of some instructions.
Then remission.
Where is the instruction? Where are the instructions?
then remission do that, lord.
18 matter, we cannot adjourn this matter. On the basis of instructions, we can dispose this of.
My lord.
Yes, you tell us how to resolve this?
So as his plot of land outside the camp of the army step, Lordship, then he can approach the authority, Lordship.
My DAG number should be, my lord, removed from that government land, my lord. Because there is a mutation order, my lord, page 16. As per mutation order, my lord, it is done, my lord, page 16, my lord.
Now, where is your representation? If
The
the
page,
instructions obtained by Mr. Goswami is in favor of resolution of the matter, we can direct passing of an appropriate order, speaking order.
page 28, my lord.
It's item number 22. 15.
Huh?
What is your name? Your name?
My lord,
Your-
petitioner name, my lord.
No, your name.
S. Hazarika, my lord.
Mr. Hazarika, we record the basic facts and in view of the instructions which Mr. Goswami is having, we'll direct you to file an application.
My lord,
Which will be the-
application on the basis of freeing the land from the land acquisition.
Yes, yes.
That is the
Heard 3 S.
My
Hazarika,
lord,
Learned Counsel. You are not on record, Mr.
my
Hazarika.
lord, I am appearing on behalf of D. Sharma, my lord.
On behalf of D. Sharma.
D. Sharma.
Heard 3 S. Hazarika, Learned Counsel appearing on instruction of 3 D. Sharma, Learned Counsel for the petitioners. Also heard 3 N. Goswami,
I got 226, Lordship.
Learned State Counsel. One is also there, one revenue, along with Miss P.R. Mohanta, then Standing Counsel, Revenue Department. Para? The writ petition has been filed, or was instituted in the year 2018 with the following prayer, page 10, prayer to put it. Para? Sri Hazarika, the Learned Counsel for the petitioner. Petitioner, I don't know. Petitioners has contended, has submitted that they are the owners of a plot of land measuring 1 bigha 3 katha 12 lecha covered by patta number 120, DAG number 273 of village Koita Sidhi, Mouza Chayani in the district of Kamrup. Full stop. In the year 1976, a plot of land was acquired and due to some mistake on the part of the revenue official, the DAG number 273, in which the plot of the petitioners is located, was included in the acquisition order. Full stop. As a result thereof, the names of the owners were struck off in the records of right. And the land was shown to be Sarkari in view of the acquisition process. Full stop. It is the specific case of the petitioners that their land was not the subject matter of the acquisition process, and therefore a direction has been sought for exclusion, for rectification, so that rectification, full stop. It has also been contended that because of the aforesaid circumstance, the petitioners have not been able to pay the land revenue. Para. In this case, written instructions were obtained which have been placed on record. Full stop. Para. 3. Goswami, the Learned State Council, has submitted that though affidavit in opposition as such has not been filed, as per the instructions obtained, it appears that the plot of land covered by DAG number 273 was not the part of the acquisition proceeding. That is your instruction, Mr. Goswami?
It is not present.
He has also referred to a joint verification carried out in this regard. Para. Considering the aforesaid facts and circumstances and the submissions advanced on behalf of the government, including the written instructions, this court is of the view that interest of justice would be served if the petitioners are permitted to approach whom?
Circle officer. Madam.
Approach the appropriate authority, namely the circle officer. Which circle?
Circle officer of, my lord, Polasbari Revenue Circle, my lord. Polasbari Revenue Circle.
Polasbari Revenue Circle for carrying out the necessary correction. Full stop. The same may be done within a period of 15 days from today, and upon submission of the same, the application is directed to be considered and appropriate steps taken in lines of the observations made in this order. Full stop. The instant order has been passed, taking into consideration that this writ petition is pending since the year 2018. Full stop. Para. Writ petition accordingly stands disposed of. The outcome of the exercise is to be communicated to the petitioners by a speaking order.
My lord, the correction will be done on the basis of the joint verification report.
They have also already mentioned.
Obligement.
And also while undertaking the exercise, the authorities would also take into consideration the joint verification report.
Obligement.
Yes, Mr. Sarkar.
Matters, I'm the petitioner in this case matters. And the matters here in this case matter, the petitioner declares to be foreigners in the
How many of you are there?
matter.
How many of you are there? How many petitioners are there? 3.
Only one petitioners in the foreigners tribunal case matter.
Now, how many petitioners are there in this case?
Three
3. Tell us. 3 petitioners.
petitioners.
What are your grievances?
Petitioners are declared to be foreigners. in
All
disputes
of you?
60, no, only one.
Petition number 1.
One.
Declared foreigner.
Foreigners in the year 66 and 25th March 1971 matters. In between these periods, he was
In the
declared to be
stream
foreigner.
66 to 71.
According accordingly, under section 6 of Foreigners Act, petitioners registers his names as a foreigners matters. The registration applications is here included matters. And matters after 10 years, when the NRCs came, petitioners applies his names in the NRC, but his name was not appears in the NRC records. Due to the reason is that he was declared as a devoters. Due to devoter list, his name was not entered in the NRC. Miller said, in this case, Miller, I have similar natures of case. I have annex one annexer E Millers, similar
Mr.
natures
Ali?
of case where the
Is it covered?
given a direction, this honorable.
For devoter, one is required to
Approach
approach the foreigners tribunal.
In this case, the annexer P, that is in page number 17, he has registered, he has submitted the registration form to the foreigner section office. That is a 1989 lordship. And as if it is marked D, then he will be marked after 97 or in 5 lordship. So subsequently, here in the petition, he has not mentioned in which constituency he has been marked as D lordship. So under circumstances, it will be difficult for us to obtain the instruction as regards where he has been marked as D. Although in the NRC, he has submitted the NRC.
Where is the demarking? Which constituency? Where is the voter list?
Kamrup rural.
Where? Have you given?
Rural Millers, I have not annexed
Have you
the
made the averment?
annexed the list Millers, hairs Millers,
Have you made any averment?
Millers.
There are 3 petitioners. So one is Ranjit Paul, who has then order in his favor by the foreigners tribunal that he is a foreigner of 1967 stream lordship. And here there are 3 petitioners.
Three petitioners.
One is Madan Paul, son of Ranjit
Son.
Paul. And again, second is Madhu Paul, son of Ranjit Paul. If they are also marked as D lordship, then they will not be covered by this judgment lordship, by the order of the foreigners tribunal 1989 lordship. So if then
No, Millers, I've not came against the orders of foreign tribunal, Millers.
Now,
Have
why 3 petitioners have joined together? The cause of action is of one petitioner, isn't it?
Yes, Millers, cause of action is one petitioner, Millers, then another two is son, Millers. When he applies for NRC, his sons was also declared as the devoters. So I highly petitioned for your lordships for 3 petitioners.
If his grievances are limited to NRC lordship, then he will be covered by the NRC Act lordship. Here, as per the NRC rules, lordship, he will have to file an appeal under Rule 8 lordship before the appropriate tribunal, and the NRC has not been finalized. So there is judgment which
Hey, Mr. Sarkar, let us get the facts cleared. See, petition number 1 was
Yes.
declared a foreigner in the
Correct.
stream 66 to 71.
71, yes,
So you have a period of 10 years.
10 years
That 10 years period has lapsed.
left,
Now you are entitled to get your name in the NRC.
NRC.
You say that since your name is prefixed, there is a suffix of D,
D,
so you have not been, your name has not come into the NRC.
NRC.
And similar is the case of petition number 2 and 3, who are the sons of petition number 1.
Son of the petition number 1.
Now, Mr. Ali says that in a grievance of this nature, you can prefer an appeal under the NRC rules. You prefer an appeal, will direct the appeal to be considered. So far as the 2 petition numbers 2 and 3, and there is no determination that you are foreigner of any stream. There is
Yes,
no
Millers,
there is no reference
they are-
also.
They are not foreigners.
There is no reference.
There is no
Reference was only against petition number 1 answered by
Yes,
court
Millers,
that has attained
orders
finality,
may
no
pass.
orders, no further challenge. No further challenge. A stream was 66 to 71. So you'll be entitled to whatever, and
My
for
lord,
that
at
if
at
D has
least the-
been marked.
Then at least the petition number 1 can be orders may pass.
Yes,
Others may-
If he is marked as D, he should inform in which electoral role and or in which constituency.
now where is the pleading?
Okay.
Your demarking is where? You said Kamrup, where
Kamrup
where
rural,
have you stated?
Kamrup rural.
Where have you stated? Where have you stated?
Report at this,
received a notice from NRC. Well, let us see the notice at Annexure D.
Annexed,
Mr.
annexed D.
Sarkar, D. Where is D?
Page number 19.
19.
Annexed D.
Please no.
And you are requested to inform.
This is a case of Kamrup district, my lord.
What is DF? On the right column, Mr. Ali? Reasons for non-inclusive
Declared for a descendants.
or declared foreigner. DF is declared foreigner.
First is declared foreigner. If DFD will be declared foreigner descendants.
Where is that order, Mr. Sarkar? That
Annexure E, lords. Here the next
no, not similar order. Where is the order of determination of his?
What's it in page number 15, lords? Annexure E.
Page number 15. Last paragraph.
Page number 15.
Yes.
14 is the type copy. We have migrated in the after what is, but before so and so.
Type copy is page 13.
But Mr. Ali, he has a case then.
As regards his, I have no objection to that. Since he has been declared as an Indian of 1671 and he is registered, his name may be he will be taken up. So it's sometimes obtained the instruction if his name is still continuing. If he just can give us the information as regarding which constituency he is being marked as D, lords. And accordingly, lordship may direct him that he may approach if he is not being removed. Or also if the electoral officer has been.
Now, why should we again burden him to approach? We'll,
It may be not be directed, lordship.
we'll direct you to
Remove the
make the corrections.
lordship.
Okay, because this order of the Foreigners Tribunal Gauhati, he has accepted.
Yes, sir.
There is no challenge to that. And that period, this order is of 1989. 10 years is over.
Testing the lordship. Only my apprehension, lordship, petition number 2 and 3, if they are also marked as D. If here they are not marked as D, then only Paul petition number 1 and name has to be removed. D has to be removed, and there is already an order in his favor. Only even give a name of the constituency where he has marked as D.
Can you give the constituency, Mr. Sarkar? We can have it tomorrow.
Constituency, that means
Voter list where he has been marked as D.
In which voter list you have been marked D, petition number 1? Voter list of which constituency?
D voter.
D voter of which constituency?
Kamrup rural.
Where have you stated? Kamrup rural is not, what is the constituency? Kamrup rural is not a constituency.
Not constituency, whether the declares foreigners list as D voters.
D voter in which constituency?
Kamrup rural.
Constituency is not a constituency.
Not constituency, my lord.
You tell us the constituency.
That was written as a declares D voters list.
Let us see where. Which document?
That is, my lord, sir. I have not collect the D
You
voters,
get the
but-
instructions at
but
least, you get the constituency.
Serial number 101, his name is there, my lord.
Page.
That list I have not annexed, my lord, sir. That's a D voter list. I have
From
not-
what orders will you pass? That will not benefit you.
Voter list.
You at least get the instructions. We can have it tomorrow. Okay?
I'll request that even extra copies are not being served on as well. Mr. Pine, I have required he also comes with the copy of this petition also.
These are old matters, Mr. Sarkar, of 18, where you don't serve extra copies.
On his absence on last occasion, notice was issued.
No, already notice, sir.
Will they do the needful notice if a copy, extra copy is served on. Like today, if you can serve on a copy.
Mr. Sarkar, please give an extra copy to Mr. Ali and you get the instructions in which constituency you have been marked as D.
My lord's extra copy, his name is there, my lord's Ranjit Pal. This is. Well, it was annexed, my lord. Yes, an extra.
Hmm?
Extra copy.
Wrong year.
Extra copy didn't know. The extra copy.
Tulsi wrong year. Page 12. What is this? This is another IA. IA for?
No. That was another case, my lord. His list, only list, my lord. List, his name is there.
Mr. We cannot rely upon it. Plus have a look at this.
Yes.
So this is the address. I'll just.
101. Tulsi wrong year.
Untraced declares foreigners.
Post. This is a list of untraced declared foreigners of post 71 also.
Oh, this is the address.
That will be more doubtful. That means he is not casting both lots of, something, if he is casting both, then from which constituency? And in this list, it is saying that untraced declared foreigner post 71. But the order he the next year is of pre
66 to 71.
Then there must be some other order also might be against him. These documents will order.
You take instructions. Okay.
Finally, also take instruction.
Okay.
He was there, but because of.
Madam, you take instructions on this case. Okay. Heard Sri H.A. Sarkar, learned counsel for the petitioners. Also heard Miss, what is the name? Miss A. Payang, learned counsel appearing on instruction of Ms. Sri J. Payang, standing counsel, Home Department, Home and NRC. Also heard Sri A. I. Ali, learned standing counsel, Election Commission of India. Para? Para? As per the case projected, the petition number 1 was declared a foreigner in the 1966-1971 spring in the year 1989. It is contended that even after expiry of the 10 years period, the petitioner number 1 has not been given the benefit of his name being included in the NRC. It is also contended that the reason which is discernible is that there is within word marked against the name of the petitioner number 1. The petitioners have also annexed a document to show that while petition number 1 is marked as declared foreigner, DF within bracket declared foreigner, the petition number 2 and 3, who are the sons of the petition number 1, have been described as DFD within bracket declared foreigners descendant. Para? Both Ms. Pang and Sri Ali, learned counsel, are directed to obtain the instructions. Para? Since this matter is pending since the year 2018, instructions are to be obtained expeditiously and the matter is directed to be listed on the 13th of March. For admission hearing. I think yes, hearing is for admission. Admission.
Item 14,
Lordship, item 13 I mentioned in the morning
Yes.
might not have been noted. Your Lordship.
Yes. 13.
We'll get instructions from our client tomorrow.
That contractual matter.
Yes, Your Lord.
There will be nothing. Where is Mr. Who was there? Parashar. Where is he? Okay. Well, we'll close this.
Yeah,
Okay.
Lordship. Tomorrow
No, we'll close this.
we'll just get instructions, Your Lordship, if the cause of
No,
action still survives.
we'll ask for a new process where you will be given opportunity to participate, because no point holding back a notice in writing tender for the year 2016 for 10 years. Okay. What is your name?
A Goswami, Your Lordship.
heard Sri A. Goswami, learned counsel appearing on behalf of Sri
P. Mohanta.
P. Mahanta, learned counsel for the petitioners. Full stop. Also heard Sri K. K. Parashar, learned. He appears for whom? CGC.
Yes, Lordship, for the respondents, all the respondents.
For the CGC, for all the respondents. Para. Please have your seat. The instant writ petition was instituted in the year 2016 with the following rare page 19. Full stop. Para. As per the facts projected, comma, the petitioner firm, which is a registered contractor, had a registered contractor under the military engineering services had applied against a notice inviting tender for maintenance of street/security light and allied works at camp area and 19 wing AF under Psilaba, which was what was the date? Which was in the year 2016.
16 years.
16, full stop. It is the case of the petitioner that his bid was illegally rejected and immediately thereafter a fresh tender was initiated. Full stop. Para. This court wide order dated 21/11/2016 had passed an interim order that in respect of the retender, comma, no bids were to be accepted. Full stop. Subsequently, subsequent orders have been passed not to take further steps in the retender dated 8/11/2016. Full stop. Though it appears that there was that the interim order was not continued for some time, comma, wide and order dated 21/2/2017, it was clarified that the interim order shall continue until further orders. Full stop. Para. The work in question was for maintenance of street light, etc., which was initiated in the year 2016. Full stop. More than 10 years have, almost 10 years have elapsed. Full stop. This court is of the view that the work in question is directly connected with public interest, which is for providing street lights in the camp area. Full stop. In that view of the matter, comma, while the earlier process, including the retender, are interfered with, comma, the respondents would be at liberty to initiate a fresh tender process, if so advised, in which the petitioner, if interested, would be given fair opportunity to participate. Full stop. The writ petition accordingly stands disposed of. Interim order passed earlier stands vacated.
Item 19.
Item 19. Yes.
Yes, sir, Lordship. Senior counsel lags in court number 2, Your Lordship.
Who?
Dr. Ashok Saraf.
Okay, he'll be okay. For industries, you'll be there. Okay, what is the matter?
Subsidy.
Central subsidy scheme.
Subsidy.
For newly established unit and units which have substantially improved.
Subsidy under which plan, which policy? 2007.
2007 years.
And all standards by the, there is no guideline.
There is no
no central government guideline, we have not received as yet. So we have been writing to the central government.
Who is, CGC is a party here? Yes, Union of India. Who appears for Union of India? So Locker, you are appearing. Have we got the instructions? Okay, we'll have it on Tuesday next then.
Yes, sir.
Okay. A prayer for adjournment has been made on behalf of Dr. A. Saraf, Senior Counsel for the petitioner. Also heard Sri BJ. No, don't also heard. Also no. Sri BJ Talukdar learned State Counsel for the Industries and Commerce Department and Sri Locker, PS Locker learned CGC are present. Para. List for admission hearing on Tuesday.
Yes, sir. Also, only Industries and Commerce have filed the affidavit in opposition, but Union have not filed the opposition.
See, 1822 matter, if there's a prayer made, we'll consider.
Yes, sir. Publish.
Please give an extra
Yes.
copy to Mr. Locker.
23.
Your Lordship will pass over the matter for the time being. Mr. Sigdar is on legs.
Who?
Mr. Sigdar, A.R. Sigdar.
What is this matter?
It's a eviction matter, Your Lordship.
I'm paying, Lordship. And Lordship, I'm paying for some time. Because Lordship, I have sent the affidavit and yes, I have received the affidavit also, but due to some mistake, Lordship, I could not.
Okay, you filed the affidavit. Okay. While a prayer for accommodation has been made on behalf of Sri A.R. Sigdar, learned counsel for the petitioner, Sri P.S. Locker, learned CGC, has also prayed for some time to enable him to file the affidavit in opposition. Full stop para. In view of the above, matter stands adjourned to be listed on 16th of March, by which time the affidavit in opposition is required to be filed.
Lordship.
26.
Yes, what is this?
In my humble submission, the representative.
Yes, Mr. Bodua.
Yes.
Yes, what is it?
Your Lordship, our senior counsel is attending the matter through the VC.
Who will be appearing?
Your Lordship, my senior counsel
Who, name.
Bharat Rai Chandani. Veer Chandani, please allow him to enter.
Yes, where is
This is
it?
a
Yes, Mr. Pukal.
What's it? They have challenged.
May it please, Your Lordship.
Appellate order
Yes.
on the ground that multiple notice cannot, single notice for multiple years cannot be issued. And there is no appellate tribunal.
You have filed your pleadings.
Lordship, in my humble submission, it is not required, Lordship, because our High Court has already decided this issue by coordinate principle. And regarding Lordship alternative remedy, the appellate tribunal started functioning from January 21,
January 2026.
2026.
Mr. Raichandran, are you aware of this development?
My lords, may I just point out, lordships may kindly see the order by which lordships had issued notice. These very contentions were raised by my learned friend. If they are not wanting to file a reply, my lords, I can go ahead with the matter. But then after hearing, my lords, last time also they did the same thing and they said we want to file a reply. Lordship may kindly see the detailed order passed by your lordships.
Lordship, on last
If they
occasion,
don't want to file a reply, my lords, I'll go ahead with the matter.
reply
I'll
copy was
satisfy your
there.
lordships
Recently, they have
that
supplied
this is
copy of
wholly
the
without
storage already-
No,
jurisdiction.
Mr. Kahil, let there be no argument on this matter. Let there be argument on the merits of the case.
Not-
Are you willing to file a rejoinder, a reply, response?
Today, similar matter are listed before court number 10 as well as court number 7. In both the cases, we have filed affidavit in reply. That will cover our case also.
No, in that case, those cases have to be brought together. If you're relying on an affidavit filed in another case, you have to serve a copy of that affidavit
Lordship,
to the learned counsel so that they are also equipped.
it may be
my learned friend is appearing in court number 10 also. Item number 9.
Your
No, we can have a common hearing of those matters. When are those matters fixed?
Today is
today. One is fixed today. Your
court number 9. And
Court
Lordship,
10.
Court number 10.
Court number 10. This matter can go to the court number 10, have a common consideration.
Lordship.
Mr. Chandani, what do you say?
Lordship. Lordship,
Let there be
please,
a
I am in
common
my lord's
consideration.
hands, my lords. I am in my
Okay.
lord's hands. Lordship,
Okay.
please.
You are R. Chandani.
Bharat
Heard
Rai
three-
Chandani, lordships.
Huh?
B. Rai Chandani.
B. Rai Chandani. I heard Sri B. Rai Chandani, learned counsel for the petitioner who has appeared online. Also heard Sri S.C. Kyle, learned standing counsel, senior standing counsel, CGST, as well as Sri B. Chaudhary, learned standing counsel for state GST. Full stop. This court has been informed, though no returns have been filed in this case, this court has been informed that similar matters have been listed today in court number 10, being WPC
2922
2922
of 25.
25, one matter,
Yes, Lord.
25, in which in court number 2922 of 2025, full stop. Sri Kyle, the learned standing counsel, is informed that affidavit in opposition has been filed in that case, which would also cover the issue involved in this case. Full stop. He has also informed that it is the same set of counsel who are appearing in that case. Full stop. Para. In that view of the matter and in the fitness of things, this court is of the opinion that an analogous hearing would be required. Full stop. This full stop. Para. Accordingly, it is directed that the present case be listed along with
2922.
WPC 2922 of 2025, which is listed today in court number 10. Full stop. The registry may transmit the records of this case and tag along with the records of so-and-so for an analogous hearing before the appropriate court.
Lords.
Much obliged.
Okay.
Much obliged.
Lordships, may I just, my lords.
If you want to move it today, you can have it today itself.
Indeed, your lordship. The series is 26, item number 26, 27, and 28. All of them.
Okay.
Are together, my lords.
But you said one case, one you have filed affidavit.
Yes, you know.
There are two other.
In court number 7 also similar issues there. Lordship, that is parted in court number 7.
And 10 this is there.
10.
Oh, okay. Great.
Lords, my lords, may I just make one submission? Lords?
Yes.
The interim to continue, we'll make a mention.
Okay, interim order. It'll be today itself. Interim order stands extended till the next date of consideration, till the time of consideration.
Lordship, please. Grateful. We are obliged. Obliged. Grateful. Item 29.
এইটো ৰেকৰ্ড তাতে গুচি যাব হা আমাৰ এইটো Yes, madam. HRA Chaudhary, HMR Chaudhary, SB Laskar. 12 matter. Oh my God. It was dismissed for default. Yes, where are the petitioner's advocate? Have you seen them? Mr. HRA Chaudhary, AMHR Chaudhary. We'll have this as the last item, okay? But matters, so all matters we are not going to adjourn. Matter is pending since 2012, I think, 12. It was dismissed earlier, it was restored. Again, it was dismissed, again restored. Now, we may not say anything on merits, but we'll dismiss for default. We're getting a further chance. We'll have it as the last item. Please inform.
We are aggrieved by Annexure 25 order. What happened in this case, my lord? I was assigned with a contract to construct the building of Silchar Municipal Board. That was to be carried out in two block A and block B. Now, I'll show from record that block A was never handed over to me in spite of my repeated representation. The block B are duly completed. Then everything was agreed to by municipal board, but finally this order has been passed, slashing a cost of 55 lakh on me due to delay in completion matter.
What about arbitration?
My lord,
What about arbitration?
arbitration clause is not there. I enclose the contract, my lord.
Okay, we can hear this matter. It is for hearing only, yes. Mr. Dr. for Silchar Municipal Board.
Now it's corporation.
Silchar Municipal. Yes, Mr.
On page 25 is the NIT.
There was an NIT.
NIT, my lord.
For
construction, Lord, we kindly say page 25.
25.
Down below, the table.
25
construction of the multi-utility building at Silchar under 10% pool fund.
9/4/2012. Short tender notice.
Madam.
For construction of
multi-utility building at Silchar under 10% pool fund. It was issued by Silchar Municipal Board, my lord, chairperson of the Municipal Board, my lord. Then, my lord, the period was 24 months, my lord. You will find in the schedule, my lord. Then my bid was accepted with page 29, my lord.
Okay.
Page 29, my lord. My bid at 17% above the SOR, my lord, was accepted. And it was also mentioned that the time period will be 24 months, the last paragraph.
19/6. What is the order date?
That is, my lord, 19/6/2012, my lord.
19/6, your bid accepted.
Bid was accepted. My bid was.
Yes.
Then, my lord, I have given a bar chart, my lord, page 30. I have given the program.
No,
You will find page 32. In what manner the work to be executed, I inform the municipal board, my lord.
Okay.
Plus, you will find the chart, my lord, from serial number 4 to 12, this is regarding block A. Now, time schedule Lordship will find from July, August of 2012, then September, casting, first floor, second floor, third floor. These are all dates as per the schedule given 2012, 2013, my lord. Then starts the block B. Now here, my lord, block B was completed nicely, my lord. That they have accepted it.
Block?
Block A is in issue, my lord. So block A, Lordship will find. This is the
There are two blocks.
Two blocks, my lord.
Construction of multi-utility building, two blocks.
Two blocks, block A and block B.
Okay.
The whole issue is that they are saying that I did not complete block A. Now, block A time schedule has been given, my lord, how, in what manner it is to be executed. In a bar chart I have given, my lord. Then contract agreement, Lordship will find at page 34.
So far, block B is concerned, there is no problem.
There is no issue, my lord. I have duly done it, my lord. My contention is that they were continuing their office, municipal board office in block A site. They did not give possession of the site. And by that time, the time elapsed, my lord. So contract agreement timing, Lordship may skip. I'll come back to it later on, my lord, when the we'll make some submission regarding that, my lord. And formal work order at page 52.
Okay, we'll rise for 5 minutes. We'll come.
Page 52, my lord.
32.
52, my lord. Annex 5. This is the formal work order given to me, my lord, on 1/8/2012. Tender value so and so. Time for completion is 24 months.
Yes.
So
this is for both block A and B.
Both composite. My lord, this is relevant because from this only 24 months starts. So that would be 31/7/2014. Now the block B site was handed over to me. I was carrying on it in full speed, my lord. The block B could not have been given because the whole office was running.
A could not have been given.
My lord. B I was completing, my lord. So I made a representation for handing over the site, page 53, my lord. Only 8 months left, my lord. Even then, my lord, this was the position. In the third paragraph, I would like to read, my lord.
Yes.
Third paragraph, my lord. It may be kindly be mentioned in this connection that the total volume of the work in all respects relating to block B, western portion, as per bar chart forwarded to you by letter number so and so, is almost in the stage in the verge of completion. But as regards the working activities in respect of block A eastern portion, as per the bar chart in question, no work is possible to start till now due to non-handing over of the site after demolition of the old Assam type building. Therefore, it is earnestly requested to your honor kindly to arrange for handing over the complete vacant construction site so as to get it ready and fit for starting construction activities at the most earliest possible time. In case handing over of the site of block B is delayed further, then it may not be possible to carry out the work at the existing rate after expiry of the time of construction. Only 8 months left, my lord. Even then, site was not given. Then, my lord, I have given photograph of site A, site B, not that very clear, my lord. But Lordship may kindly have a look, my lord.
Page?
Page 55, my lord. That I enclosed with the representation, my lord. Page 55, lordship, middle portion, lordship will find a Assam type construction.
Hmm.
And page 56, block B was complete.
Yes.
Then, my lord, I made successive representation, my lord, page 57, 58, and 59. '57 is on January 2014. Then page 58, Annexure 10 is on 4/8/2014. Time is already gone, my lord. The last date was 31st July 2014. And
Yes.
then Annexure 11, my lord.
Page.
Annexure 11, page 59. Page 59, here, my lord, this representation is on 5/9/2014, my lord. The block B western portion of the above construction work was completed in December 2013 and handed over to you during the same month of your for your use. However, the construction of works of block A eastern portion could not be initiated because of the non-handing of the site, the work site, to me within the stipulated contract period, which expired on 31/7/2014. This fact was brought to your notice through my letter of dated 4/8/2014. If you are, however, interested in the resumption of the left out work, block A portion, the following factors may kindly be taken into consideration. The completion of the date of the entire above work has already expired and so and so. As such, if fresh period of completion needs to be incorporated after the amendment of the contract, and the price escalation of labor and materials may also please be taken into consideration. So I was basically asking for a new time frame and price escalation. The same work could not be, which was 2 years before, the same price I could not do it, my lord. Now, in response, my lord, Annexure 12 may be seen, my lord. They have given a response in respect of my taking a stand, my lord, which is contrary to record.
Which one? Page 60?
Page 60, my lord. They have given a vague reply.
Yes, what is it?
My lord, page 60, it says that, my lord, may I read it, my lord?
Please read.
One paragraph, my lord.
Please read.
With reference to the subject and later cited above, I would like to inform you that the work site had been handed over to you long back on 1/8/2012. 1/8/2012 is the starting point, my lord. You have already executed 50% of the work approximately, and say 80% of the payment against the execution has also been released. So there is no question of handing over the site once again arises. You were therefore requested to complete the site building immediately as per approved plan and estimated as per final report. Further, you were hereby reminded that as per the agreement, the construction of the building was supposed to be completed within July 2014, which is already over. If you need any more time, you may appeal for extension of the time showing specific month and year. Here, my lord, this letter has been referred to in later on also, letter. They are saying that 1/8/2012 already handed over the site. There is no question of handing. Issue is that, yes, site was handed over, only B was executed. Admittedly, they were running their office in block A. So there was no question of. Now, my lord,
What is your grievance, Mr. Chakraborty?
well, the grievance is finally, this is going on. Lordship, kindly, I have only some documents left over. Finally, they called me, they cleared my bill. They have said everything. They said that we have taken up the matter with the directorate also. All of a sudden, my lord, this impugned order has fine after, my lord, in 2020, this is under challenge.
Regarding
My lord,
impugned order regarding?
regarding saying that holding me entirely responsible for delay in causing block A, my lord, say that I am to be slashed with a cost of 55 lakh,
Oh.
53,000, all money deducted, and say that 14 lakhs still 16 lakhs.
Mr. Baba, Doctor,
Yes.
how do you resolve this?
My lord,
Block B appears to have been done by him in time. Block A, the sometime
not the correct position, my lord. I'll just.
sometime building was still there.
End of 2013, my lord, it was handed over to him on 1/8/2012 itself.
No,
There
he's
is
not
no
disputing. He's not disputing
My lord,
regarding handing over the site. He is only raising a question that in the two blocks, so far as B is concerned, it was a vacant plot. He had constructed the house, multi-storied. So far as A is concerned, we find that even after construction of block B, in RCC structure,
my lord.
the A-type structure was still there. So it appears
that
that there has
is-
been some delay. It can be sorted out, I think.
I'll explain it, my lord.
No, we have not.
After
We
the-
will complete with Mr. I'm just
Right.
trying to have your response, immediate response.
Right.
Okay, these matters can be so resolved, I think. Why don't you
My lord,
resolve
it has
this?
been cancelled, and your lordship will find he has himself said in paragraph 15 of his writ petition that since escalation is not there, I am not in a position to do it. He has said very
Yes.
candidly.
See, Mr. Doctor, you may have many points to urge on your behalf. See, ultimately, public interest is involved.
No, it is our building itself. It's a municipal office.
No,
building.
public interest is involved. It's your building. It's meant for the public. He has some reasons that since the entire site was not made available, so he could not go ahead with A.
That position is not correct.
No, that is his version. We are not saying that's a correct version.
No.
But the end result is that within that stipulated period of 24 months, the matter, all the constructions in total could not be completed. He could complete block B. A was still to be completed. And the matter remained there. And he has also made a request that if either you extend the time and you also consider escalation part, because within a period of 24 months, the prices might have gone.
In the terms of agreement, my lord, there is no escalation. Escalation will not be given. It was very specifically given.
No, Mr. Doctor, saying escalation will not be given, per se cannot be accepted because escalation within the time stipulated will not be given. Now he is making whether his request is bona fide, considerable or
Right.
not, that's a different matter. He is not asking for escalation within the period of contract. He is asking for escalation that you extend the time for making construction of block A because I was not given the space. And if I have to do it, I am willing to do it within an extended period of time and after considering my prayer for escalation. That is his projection.
My lord.
Whether it's correct or not, it's a different matter. Now, BA has also been done by somebody else.
No, it's a because the pendency of this case, my lord, we could not drop it.
Why don't you sit and decide?
That is, of course, your lordship is right that way.
You sit and decide. See, public interest is, I think it's a fit case for mediation.
Your lordship may, I think.
Mr.
Yes, lordship is correct.
I think you should make an attempt.
Yes.
If they call me, of course I can sit, no problem. my lord.
Oh, I see. No, it'll be done in a mediation. It can be done either at Silchar or at Gauhati under our High Court mediation. It's a fit case. This can be resolved. We are not.
My lord, one thing it may be centered there. Mediation at Shilchar.
I think that will be better.
That will be better.
In fact, instead of asking both the parties representative to be
Both
here,
of us are from there.
or from there, we can have it there.
It's better.
But issue would be, my lord, what I understand, issue is only
See,
escalated.
Mr. Chakraborty, you are a trained mediator. You know what issues can be here in
Yes,
the
madam.
court, what issues will be there in the mediation.
No,
Everything
madam.
can be resolved.
If there is a possibility of escalation, possibility it can be settled. If they say that today also I have to.
See, if we do not, if the mediation is successful,
My lord,
we do not know what would be the result.
my lord, my lord.
It can
That-
be a result that you are allowed to do at a different rate. It can be a result that you resolve the matter, it will be done to somebody else. We don't want the matter to be, construction to be stopped because of a pending
my lord,
litigation.
No, I understand one thing, my lord. What you following from your lordship's point is very correct. Because now, my lord, I'm not so far this submission is not on behalf of my client. What I'm saying,
Supposing, my lord, it's given to the mediation and something comes out, it's not bad idea. Because ultimately, supposing we give it to somebody else, the rate will be much higher than earlier.
Yes.
So therefore, keeping back in mind, the matter.
No, see, in a mediation, you can say anything.
Yes.
These are not part of the court proceedings.
Right.
It's nothing to do with your submission before a court. If it fails, you'll not be prejudiced by, or you'll not be, there is no question of estoppel or anything. You
I
can,
tell my client, the matter.
My lord, I also have an instruction, the block B that has been made, that is sufficient to accommodate everything of their office. So maybe,
see, this has to come from Mr. Doctor.
well,
He's the owner.
yes,
The
my instruction
requirement
I'm
of,
saying. Yes,
what would be the adequate requirement is up to the owner. If he
Lordship is-
thinks that yes, this building will suffice, then
That is, my lord, how they can.
No, but just, I'm not saying instruction from, I'm not saying something.
that is what you are to take that call. You're the best person.
Maybe
How much
they are-
place you need. And the bills which have been cleared for block B,
Everything has been cleared.
that is only for B.
B. My no-
Some other things were like lift, then the garage area, then the floor was not fitted with tiles and all that. These were not done.
Lordship, 2-3 papers I may show, my lord.
No,
Municipal board has given me.
we'll pass an order. We'll have the matter tried for a mediation.
The only thing is that the matter will be pending, I suppose, my lord.
Obviously.
Yes.
Without coming to a conclusion whether the mediation has succeeded or failed, even if it succeeds, we have to pass an
My
order.
lord, my lord.
I think if both the parties cooperate, I think it can be sorted.
Yes. Heard. Sri B. Chakraborty, Learned Counsel for the petitioner. Also heard. Mr. Handik, who is respondent number 1? Also heard Sri J. Handik, Learned State Counsel, as well as Sri S. Dr. Learned Senior Counsel for the Silchar Municipal Corporation, within brackets, erstwhile Silchar Municipal Board, assisted by your name? Astrom. Para. Please have a seat. The subject matter pertains to a tender for construction of a multi-utility building which consisted of 2 blocks. Briefly stated,
The work order, it's not that block A and block B. They have formulated that.
That is not being disputed in reply also, my lord.
No, this
In
is
so many papers.
What I'm saying, the work order.
okay,
is-
okay, no. The petitioners have contended that there were 2 distinct blocks, Block A and Block B. And so far as Block B is concerned, the constructions have been done to the full satisfaction. Construction is done in its entirety, and the amount has been released to the petitioner. First of, however, so far as Block A is concerned, due to non-handing over of the clear site, the work could not proceed. And in the meantime, the stipulated time of 24 months had expired. The petitioner claims to have made several representations, including an offer to complete the other aspect, which the petitioner has termed as Block A, on
This is mentioned in the impugn order, block A, block B.
Block A,
This is not required, madam.
Block A, within an extended time and after consideration of his prayer for escalation. Para. Sri Datta, the Learned Senior Counsel, has, however, strenuously disputed the projection made by the petitioner. Para. Be that as it may, taking into consideration the facts and circumstances, and also the aspect that the construction in question involves public interest, this court is of the opinion that an attempt be made for resolution of this matter through mediation. Full stop. Para. This court accordingly directs the parties to appear to make an attempt for resolution by mediation. Full stop. The mediator is required to be appointed by the concerned district judge. This is of Kachar. Kachar.
Guwahati, you could have better guide, my lord, in the proceeding. My learned fan and me, my lord, here. You could have better guide this, understanding the issue, as you please.
It is between the parties only.
My lord, my lord.
Amongst the from the list of mediators. Full stop. The to facilitate an effective consideration, comma, let a scanned copy of the entire case records be transmitted to the office of the learned district judge Kachar for placing it before the appointed mediator. Full stop. The parties who are represented by learned counsel are directed, who are represented before this court are directed to appear before the mediator on, we give a date because there has to be, other it will be off track. On today is 19th. On 13th of March, you don't need 13th, on 9th of March, prior to which the process of appointment of mediator, prior to which the aspect of assigning the matter to a particular mediator is to be completed by the learned district judge. Full stop. The mediator, the learned mediator is required to prepare a preliminary report and place and transmit the same to this court through the office of the learned district judge before the next date, which is fixed, before the next date fixed in this case, which is, we are giving on 9, on 1st of April, depending on which depending on which further orders will be passed. Full stop. So 9th, he will be appearing before the mediator. Will ensure that the scanned copies reaches the district judge within a very short time, and let a copy of this order be furnished to the let a copy of this order accompany. Okay. Family কোনটো আছে জানো আহিছে নেকি মাত্ৰ Yes.
Pardon.
This matter was restored, dismissed for default. Again, you are defaulting. We could have dismissed, but we did not. Taken it 8 to 20. Yes, what is it?
Lordship, yeah, my lord, I challenged my lord annexer 4, my lord.
Page
26, my lord.
Please narrate the facts first.
Lordship.
Please narrate the facts. What are the facts?
Lordship, fact is that, my lord, yeah, my lord, 1990s.
What is your name? Your name?
H.A. Laskar, my lord.
H.A. Laskar. And Mr. Gyasuddin, you are for whom?
Respondent number 3 and 4.
Mr. Handike would be appearing. You did 3 and 4.
Yes.
Borpuja is also there. Revenue Department. Okay, yes. What is it, Mr. Laskar?
Lordship, in the year 19
1996, my lord, and 97, my lord. Name of the private respondents was mutated in the revenue record, my lord.
Private
And-
respondent number 3 and 4.
Yes, my lord, review appellant in Board of Assam Board of Revenue, my lord.
The private respondents,
Private respondent.
3 and 4, their names are mutated.
Mutated in the year 1996, my lord. And this mutation was cancelled by order dated 28/9.
Cancelled.
Yes, my lord. Later on, it was cancelled. Ah, 28/9/2010, my lord, in NRK case number 49/2006, my lord. 2006 and 2007.
29.
Yes, my lord.
Case number 29.
49, my lord.
49 of
NRK case number 49/2006/7. Passed by the additional deputy commissioner, my lord, Nagaon.
Nagaon.
Yes, my lord. And my lord, private respondent, my lord, challenge this order before the Assam Board of Revenue, my lord. And case was registered in Revenue Appeal case number 8 within bracket RA within bracket N / 2011, my lord. And
Mr. Gauhati, have your seat.
2011, my lord. And Assam Board of Revenue, my lord, on 12/10/2011, my lord, passed the impugned order, my lord, in favor of the private respondent, my lord.
You had contested that proceeding.
No, my lord. Later on, my lord, they filed this petition without adding me as a private respondent, my
Oh,
lord.
who are you? How are you connected to this land?
I am the co-partner, my lord. My name is recorded in the revenue record, my lord.
Yes.
Then, my lord, we filed the review petition, my lord, in revenue appeal case number 8/2011, my lord. And review petition is registered as 3 RA within bracket N review RBW of 2012, my lord. And the same was dismissed, my lord, on the ground that the same could not be entertained by the same court, my lord.
Dismissed when?
Dismissed on 5/3/2012, my lord. On the ground that, my lord, the same could not be entertained by the same court, my lord. So we approach this honorable court, my lord, by aggrieved vote, the order dated 5/3/2012 and 12/10/2011.
Okay.
This is my case, my lord.
Okay. What are your grounds?
Grounds, my lord, we are original Patadar, my lord, in the year.
But it is a matter of fact that in the ABR, before the Assam Board of Revenue,
Yes, my lord.
in RA 8 of 2011, you are not made a party.
Not made a party, my lord.
Yes, Mr. Gauhati.
Page 19.
Without even going to the merits, don't you think that if he is a co-partner, he is required to be given a hearing because the entire your grievance was against cancellation of mutation?
Yes, my lord.
So far, my lord, the mutation, this originally it was first by the, my lord.
ADC.
ADC, yes, page 19. That's why I want to show the order.
19.
Yes, page 19. Next. Here, the appeal was filed by one Prabhat Malakar against this respondent number 2, 3 and another brother. So I prefer an appeal against that order before the revenue board. So making party is not a question now. He is not necessary party before the revenue board.
What is this, what is this 17? What is this page 17? You want to show page 17 or
19,
page 19?
Just one paragraph, madam. This appeal filed by Sri Prabhat under section 151 of AL
Is page
page 19. madam.
19 or 17, I think. 17.
17.
17. This appeal 17, 17.
Maybe some.
17. Order dated 28/9.
Yes, madam. 2010.
Yes, this appeal filed
By Sri Prabhat Malakar under section 151 of ALRR 1886 against the order passed by the Revenue Circle mutation numbers allowing mutation in favor of respondent number Sri Vijay Malakar, Sri Sujay Malakar, and Sri Nakul Malakar. So against this order, I prefer an appeal before the Board of Revenue. So making party is not.
this order was passed by whom?
It's
By
not-
DC.
ADC. Additional Deputy Commissioner Nagaon.
And you had challenged this in the ABR.
Yes.
And you had made the you are Vijay Malakar,
Yes.
against whom this appeal was filed before the ADC.
Yes.
And you had made the appellant here a respondent in the ABR.
ABR.
You say that the petitioners were not connected.
Not connected.
Yes.
So according to that was.
Lordship,
Whatever, madam.
in page 15, my lord, Jamabandi copy.
No, that is okay.
Yes, my
You
lord.
have a fresh cause of action, but how can you challenge? See, he is aggrieved by an order of 28/9/2010 passed by ADC in a proceeding initiated by Mr. A. You are not Mr. A.
Yes, my lord.
And he obviously files the appeal against Mr. A. Decided. How can you say that you are a party? You have to be a party in the original proceeding. Grievance was not against you.
Lordship, you are affected, my lord.
Now, if you are affected, you have to apply in the original court. The proceeding filed by Prabhat Malakar. How can you come to the appellate court?
Lordship, in revenue.
And what is his fault?
In revenue.
What is his
my lord,
fault and what is his obligation? Whom to make a party?
He is not the Pattadar.
That
my
those
lord.
those are besides the point. If an order by which a party is aggrieved is filed by an authority and for that an appeal lies,
Yes, my
whom will he make party? He'll make the party in whose favor the order has been passed as a respondent. He has done that. You may have a different right. You have to agitate independently, not in this proceeding.
That liberty may be given, my lord.
Not in this proceeding. You can. Why not? You
Yes, my
can.
that liberty may be given, my lord. Like
That
separate
liberty is
proceeding, my lord.
always there. Okay. Right. What about the coordinated? The instant application under Article 226 of the Constitution of India has been filed with the following relief code, page 12. Where, as per the facts projected, comma, the petitioners are the co-parties in respect of a plot of land in the district of Nagaon. However, in the year 1996-97, the names of the private respondent numbers 3 and 4 were mutated. Full stop. The said mutation order was the subject matter of challenge in NRK case number 49/2006-07 and wide an order dated 28/9/2010 passed by the learned additional Deputy Commissioner Nagaon. The said mutation in favor of the respondent numbers 3 and 4 was cancelled. Full stop. The aforesaid order of the additional District Commissioner Nagaon was the subject matter of challenge in Revenue Appeal case number 8 within bracket RA bracket close L oblique 2011 instituted in the learned Assam Board of Revenue. Full stop. The learned board, learned ABR, wide order dated 12/10/2011 had allowed the appeal. Full stop. It is the it is the case of the petitioners that in spite of they being co-parties, they were not made parties in the revenue appeal, for which they had preferred a review petition, being 3 within bracket RA Silopaha, bracket RVW oblique 2012, which was also dismissed by the learned board wide order dated 5/3/2012. Full stop. It is these two orders passed by the learned ABR which are the subject matter of challenge in the present writ petition. Full stop. I have heard Sri H.A. Laskar, learned counsel for the petitioners. Full stop. I have also heard Sri J. Hendick, learned state counsel, Sri R. Borpujari, learned standing counsel revenue department, and Sri G. Uddin, learned counsel for the respondent was 3 and 4. Full stop. Para. Sri Laskar, the learned counsel, has submitted that the petitioners are co-parties in respect of the land in question, and therefore the appeal filed in the learned ABR could not have been done without making the petitioners party respondents. He has submitted that in the adjudication process, the petitioners were not given opportunity to contest, and the outcome has prejudicially affected their rights. Full stop. He has also submitted that the subsequent order dated 5/3/2012 passed by the learned board is not sustainable, as the board was in a position to entertain the review petition. Full stop. He accordingly submits that the impugned orders be interfered with and the writ petition be allowed. Per contra, Sri Uddin, the learned counsel for the respondent numbers 3 and 4, has strenuously opposed the writ petition and has submitted that the projection made on behalf of the petitioners is incorrect, both on facts as well as on law. Full stop. It is submitted that the initial order dated 28/9/2010 passed by the ADC Nagaon was in a case instituted by one Prabhat Malakar, which would appear from the order itself. Full stop. By referring to the said order, the learned counsel for the respondent numbers 3 and 4 has submitted that the present writ petitioners were not connected with the said proceedings and therefore not parties, full stop. He has submitted that as the respondent numbers 3 and 4 were aggrieved by cancellation of mutation by the order dated 28/9/2010 in an application, in an appeal filed by one Prabhat Malakar, the subsequent appeal in the ABR was preferred by the respondent numbers 3 and 4 against the said Prabhat Malakar, and there was no legal requirement at all to implead any other party. Full stop. He has submitted that the learned ABR, after due consideration of the matter and after hearing the parties, had allowed the appeal. Full stop. He has submitted that in the said adjudication process, the present petitioners could not claim any role. Full stop. He has also supported the subsequent order dated 5/3/2012, whereby the learned ABR had dismissed the review petition. Full stop. Para. Both Sri J. Hendik, Learned State Council, and Sri R. Borpujari, Learned Standing Council Revenue Department, have supported the orders passed by the ABR, learned ABR, dated 12/10/2011 and 5/3/2012. Para. The rival contentions, full stop. While, as per the projection made on behalf of the petitioners, they were left out in an adjudication process concerning their rights, it is the case of the private respondents that there was no requirement to implead them as parties in the appeal before the learned ABR. Full stop. To examine the issue, this court has carefully looked into the proceeding instituted before the ADC Nagaon, which culminated in the order dated 28/9/2010, whereby the mutation in favor of the respondent numbers 3 and 4 was cancelled. Full stop. A careful perusal of the order dated 28/9/2010 would, however, reveal that the proceeding was instituted by one Prabhat Malakar, and the petitioners and the present writ petitioners were nowhere connected in the said proceeding. Full stop. Since the order dated 28/9/2010 was passed against the petitioners, against the respondent numbers 3 and 4, the law provides them a remedy to prefer review before the learned ABR, which was accordingly done. Full stop. As narrated above, the learned ABR had decided the appeal in favor of the respondent numbers 3 and 4. Full stop. It was thereafter that the review application was filed by the present petitioners, which was also dismissed by the learned ABR by the order dated 5/3/2012. The contention of the writ petitioners, is that they are co-parties. Full stop. However, considering that the order, which was the subject matter of challenge in the appeal before the ABR, was passed in a proceeding where the present petitioners were not parties, no fault can be attributed to the respondent numbers 3 and 4 for not arraying the petitioners as parties in the appeal. Full stop. This court is also of the view that there is no obligation on the part, or there is no legal obligation on the part of the respondent numbers 3 and 4 to array the writ petitioners as parties in the appeal. Full stop. The learned ABR, by the order dated 12/10/2011, after application of mind and taking into consideration the relevant factors, have passed the order dated 12/10/2011. Full stop. This court is of the view that in exercise of the certiorari jurisdiction, the scope of interference would confine only to the decision-making process. And in this case, this court is of the prima facie opinion that the relevant factors have been taken into consideration. In view of the above, this court does not find any merit in the case projected by the petitioners, and the same is accordingly dismissed. Full stop. The petitioners, however, would be at liberty to approach the appropriate forum in case they are able to establish any right in the plot of land, in the concerned plot of land.
Lordship, one thing, my lord, land, they are claiming, my lord, is my position, my lord, in page number 18, my lord, clearly stated that, my lord, on the death of recorded Pattadar Priyabala Malakar, the entire land.
If you have an interest, you approach the appropriate forum, not in this. Okay.
Lordship,
Respect to
Yes.
taken up from our court engagement, we have to part of the.
I will send it. It will last me. Ready to you.
Most of them.
Or will it 9? When do you want to have the matter? You give a date then. Which year? 22?
22.
Okay, we'll give a date.
That is completed, Lordship, already.
Okay, he'll give a date. On a joint request, will you call him? Okay.
All right.